Welcome everyone to Dorsey and Whitney's Bank Counsel Roundtable, Banks at the U.S. Supreme Court. I'd like to introduce Erin Bryan, a partner in Dorsey's Finance and Restructuring Group. Erin?
Thank you, Rima, and good afternoon to all of our attendees. I'm Erin Bryan, and I'm a partner here in Dorsey's Finance and Restructuring Group. It's a pleasure to welcome you to today's Bank Counsel Roundtable on the topic of banks at the U.S. Supreme Court. We have three great panelists for you today. Tim Droske is co-chair of Dorsey's Appellate Practice Group. Tim has led appeals and counseled clients and trial attorneys across all industries and practices on appellate strategy and litigation. Tim has worked on appeals in nearly every circuit in the Federal Court of Appeals and is admitted to the 2nd, 6th, 7th, 8th, 9th, DC, and federal circuits, as well as the U.S. Supreme Court. Eric Sherman regularly appears before federal and state courts and arbitration panels nationwide. Most of his clients operate in the banking and financial services sector. Eric handles defense of consumer class actions, litigation of corporate trust matters, aviation litigation, trust and estate litigation, and other complex disputes. Eric is also co-chair of Dorsey's Banking and Financial Institutions Industry Group. Michael Brey is a trial associate and a member of the Government Enforcement and Corporate Investigations Group. Michael's practice focuses on assisting clients with internal, state, and federal investigations. Michael also performs significant state and federal appellate work after clerking for Judge Michael Malloy of the U.S. Court of Appeals for the 8th Circuit. He came to Dorsey and has worked on client appeals before the 3rd Circuit, 6th, 8th, 9th, and the Minnesota Supreme Court. Before I turn it over to our panelists, I have a few brief housekeeping notes. Advance, thank you. Today's program will be 60 minutes. If our video is covering the slide text, please change your view by clicking on View Options at the top of the screen and select side-by-side mode. Materials and the attendance form are available for download from Dorsey's reminder email sent from events@dorsey.com. You can return your completed form to attendance@dorsey.com. We will not have time for Q&A today, but attendees may contact the speakers directly or reach out to your trusted Dorsey contact. Speaker information is included in the materials. And now I will hand it over to Tim for the presentation.
Thank you, Erin, and thank you for everyone for joining us today. Again, the focus of the presentation is going to be specifically on banking-related issues that have been decided by the Supreme Court recently, are pending before the Supreme Court, or as well as issues that are likely to appear before the Supreme Court, either this term or in the terms ahead. So while that's going to be the focus, we did just want to spend one slide just kind of giving a brief overview of the current state of the U.S. Supreme Court. Nothing too banking specific here. But of course, the U.S. Supreme Court has been grabbing lots of headlines really for the past year, going back to when Justice Ginsburg died almost exactly a year ago, a little bit more than that. And President Trump then nominated and was successful in getting Justice Barrett confirmed, prior to President Biden being elected and confirmed into office. And so that's been placed really a focus on the court now that there's this 6-3 conservative supermajority. And given that, given that all that happened right as the presidential election was happening, put a new political focus on the court. And so, one question that came up then and has continued to kind of be in the headlines is, should we have a 9-justice Supreme Court, or should it be more than that? Should additional spots be added? Just a little bit of history, the 9-justice composition of the court has been what the court has had since 1869. So there were some fluctuations prior to that, anywhere from as few as 5 justices to up to 10, but it's been the way it is now for more than a century. And President Biden, when he did come into office, did create a commission on the Supreme Court. And the final report from that commission isn't something that we're going to see until later in November, but some early drafts have been seen by the press. And the initial recommendation seemed to disfavor adding increased justices to the court. So that doesn't seem to be what the recommendation of the commission is likely to be, just recognizing that that brings with it its own partisanship, things of that nature. the recommendation that seemed to get some better traction was imposing term limits on the justices. So one of the proposals, for example, would have the justices serve 18-year terms. And so that would mean that each president would get 2 appointments for every 4 years that they are the president. While that seemed to be a more palatable option, it could also be one that's harder to enact. Unlike increasing the number of justices, that sort of change to term limits is one that arguably would require a constitutional amendment. And there hasn't been one of those in quite some time. So stay tuned to see what happens. As of right now, it's still a 9-justice court that's operating. And you know, for anyone who may have attended the Supreme Court CLE that Dorsey had, you know, earlier this month, at least in the initial term, a lot of the concerns by some or excitement by others, depending on your persuasion, for what the newly composed court could look like, didn't come to fruition, at least in the short term. While there is this 6-3 supermajority, certainly the majority of the decisions that the court issued were still largely those of reflecting consensus on the court. 43% were unanimous decisions last term, 9-0. Another 15% were 8-1. So the court agreed internally much more than it disagreed. You did see a change in that previously 5-4 decisions had about 25% of the court's decisions were 5-4, and then somewhere around 13% were 6-3. And those effectively switched last term, reflecting kind of the new 6-3 conservative supermajority. So you did have last term 24% were 6-3 decisions, 12% were 5-4. So you did have that flip. But what we'll see in a few of the cases from last term that could have impact on the banking industry, what we'll see is that, again, you weren't seeing 6-3 decisions across the board. You saw unanimous opinions, and you saw, you know, coalitions that were sometimes surprising. And so we'll see that as we kind of move into some of the next few cases. In terms of the last bullet, back to the office, I know that's something that everyone's dealing with. As you can see, all of us are giving this presentation from our own respective places. I know it's something that banks are dealing with, is the return from COVID and the Delta variant. What the Supreme Court decided to do is they are holding in-person oral arguments, something they didn't do at all last term. But they are, but there is kind of a new normal in play. So last term, with everything being remote, they went to just marching down the line in order of seniority, and each justice being able to ask whatever questions they had to the counsel at oral argument, and then moving on to the next justice. Justice Thomas was far more engaged in oral argument than he's ever been in his time on the court. And the court now has adopted this hybrid, where at first it's kind of the freewheeling, free-for-all that everyone was used to before, but then at the end provides a period of time where each justice has a chance to specifically ask any remaining questions that they may have. The thought was that was maybe done as an accommodation to Justice Thomas, but he's proven to be quite active in the freewheeling sessions. And Justice Sotomayor made comments last week that the reason that the court actually did it was because female justices were often interrupted or spoken over by other members of the court or even counsel. And so what she clarified was that this new hybrid was actually an accommodation for that reason. And so again, there's a new normal at the court, and that kind of gives an overview of where things were, where things may be headed. And we'll now spend some time discussing some of the cases from last term that have more specific bearing on the banking industry. Michael?
Yeah, thanks, Tim. Good afternoon, everybody. It's good to be here. Sorry about the lighting. It's a little Halloweenish, but I thought it was seasonal for that. The first case that we'd like to discuss, that really has, impact to the banking industry and the financial industry was a case called Transunion Llc versus Ramirez. And this was a case that involved standing under Article 3 and the Fair Credit Reporting Act. This case was an appeal from the Ninth Circuit, and it involved a class action of approximately 8,000 class members who alleged that TransUnion had not used the reasonable procedures to maintain their credit files, accurately. The main problem at issue here was the fact that TransUnion had actually designated each one of these individuals as a quote unquote specially designated individual, which in the credit industry means that effectively these people are terrorists or drug dealers or other serious criminals that it is illegal to do business with under a list determined by the Department of Treasury. What really happened was these individuals just shared the same names as an individual who was actually legitimately on the list. And the class members all alleged that TransUnion had not used reasonable procedures to ensure that that they were correctly designated as one of these individuals. The problem for this class, though, is that not everyone had that information disseminated to third parties for like a credit check. So the court considered, the question that the court considered in this case was, who has standing to bring this suit? Is it enough that TransUnion allegedly did not use reasonable procedures to maintain their credit files accurately? Or does there need to be something more to show that these class members had harm? The court decided that only approximately 2,000 of the class members had standing. And these were the ones that had their information provided to third-party businesses. That was the line that the court drew, that it is not enough for a court to, it is not enough for a credit agency to just have an inaccuracy on a credit file. That credit agency also has to injure the plaintiff by providing that inaccurate credit file to a third party for purposes of credit reporting. So the court decided that approximately 6,000 of those class members didn't have standing. Now, where I think this case is interesting is, this case involved a credit agency, but the Fair Credit Reporting Act doesn't just regulate credit agencies. It also regulates furnishers of credit information like banks and financial institutions. And it would be interesting to see how courts down the line apply this holding to possibly inaccuracies that are furnished by banks to credit agencies. Is that enough to have standing under TransUnion? The rule that TransUnion developed is that there needs to be dissemination to a third party of the inaccuracy. But one can easily see arguments starting to develop about whether that information also has to be disseminated for purposes of a credit report or for credit that in a way that would actually injure. Excuse me, my cat is moving my laptop. That would injure those class members. So I think it'd be interesting down the line to see if the courts continue to hold this line that dissemination of inaccuracy of an inaccuracy is sufficient to demonstrate standing under the Fair Credit Reporting Act, or if there has to be more if the inaccuracy comes, for example, from a bank. Because if a bank just provides it to a credit agency and the credit agency maintains that inaccuracy on file and doesn't disseminate it any further, you can see an argument that the consumer didn't have an injury there. The court also considered another issue in this case involving the rights to disclose the right to fully disclose the credit report of the class members and the right of the class members to have a summary of rights provided to them. The court dismissed these claims out of hand basically because the class members had not demonstrated that nearly any of them had even opened the letters that did not provide their full credit files or did not provide the summary of rights. So the court found that they lacked standing on those claims as well. Eric?
Thank you, Michael. Next up is Collins versus Yellen. This is actually two consolidated cases, Collins versus Yellen and Yellen versus Collins. We have the parties reversed here. The first case docketed was actually Collins versus Yellen. So if you go out and look for the opinion, that's the name you should look for. And we'll put that on the quiz at the end of this presentation. So if you joined us last year, we talked about this case and it had yet to be argued. It was then called Collins versus Mnuchin. Secretary Yellen substituted in, of course, with the change in the executive branch. The case is a fight between the shareholders of Fannie Mae and Freddie Mac on one hand, and the Federal Home Finance Agency, the FHFA, on the other. You'll recall the FHFA was created in the midst of the 2008 financial crisis to oversee Fannie and Freddie. The FHFA put Fannie and Freddie into conservatorship shortly after it was formed by Congress, and they have been in that conservatorship ever since. At the beginning of the conservatorship, Treasury made capital infusions in Fannie and Freddie in exchange for preferred stock. The preferred stock paid a 10% dividend. Now, the problem that arose with that structure is that when Fannie and Freddie were first trying to dig themselves out of the hole they found themselves in, they couldn't afford the dividend payments. That resulted in them going back to Treasury for more capital just to send part of that money back to Treasury in dividends. So in 2012, Treasury and the FHFA decided, well, we got to put a stop to this merry-go-round. And in what is now known as the Third Amendment to Treasury's senior preferred stock purchase agreements with Fannie and Freddie, they implemented what is known as the net worth sweep. Now, the net worth sweep is, well, it's a net worth sweep. After the Third Amendment, the periodic dividend paid to Treasury would be Fannie and Freddie's entire net worth, less a modest capital reserve. Now, you can see why the common shareholders, as opposed to the preferred stockholder Treasury, might not really like that plan. As the economy steadily improved, the net worth sweep resulted in Fannie and Freddie paying Treasury billions more than they would have under the old formula. The net worth sweep was eventually paused in September 2019 and terminated in a more formal way in January 2021, but that did not affect the case, which remained on the docket at the High Court. And the two broad grounds for the shareholders' challenge to the net worth sweep were this. One, that FHFA exceeded its statutory powers, being a creature of Congress, as conservator by agreeing to the net worth sweep with Treasury. And two, that the FHFA is unconstitutionally structured. Now, when the case was at the Fifth Circuit, the three-judge panel had split three ways, which fairly unusual. The case then went en banc, and the en banc court produced 6 separate opinions, 2 of which drew different majorities. And so this lands on the Supreme Court's docket, and it's just as controversial there as it was in the Fifth Circuit, with 5 of the 9 justices issuing opinions. Now, we have other things we'd like to talk about today, so I'm really going to focus on just the key aspects of Justice Alito's opinion. That opinion drew 5 votes for the entire opinion, with other justices joining parts of it, and it was accordingly the opinion of the court. So first, on the statutory claim, the court says that the net worth sweep was within the FHFA's power as conservator, and this reversed the Fifth Circuit on that issue. Justice Alito's opinion notes that the FHFA's statutory mandate is to act not only in the best interests of Fannie and Freddie, but also in its own best interest. And that, Alito writes, is a key respect in which the FHFA's role as conservator differs from a normal conservatorship. And Alito writes that the FHFA's conduct in implementing the net worth sweep meets that standard. It stopped the merry-go-round of borrowing to pay dividends. It ensured that Fannie and Freddie could continue to support the secondary mortgage market, and it stabilized that market at a time when it was very much less than stable. Alito clarified that the court wasn't saying that the net worth sweep was the best decision possible or even a particularly good one. The point was it did not go beyond the scope of the statutory authority that Congress gave the FHFA. On the constitutional question, really to no one's great surprise, Alito wrote that the court was bound by its determination in the Saylor law case from last year. You'll recall that that decision held that the CFPB's structure was unconstitutional because it had a single director with statutory limits on the president's removal power, the president being able to remove the CFPB director only for cause. Like the CFPB, the FHFA has a single director with statutory limits on the president's removal power. So as in Saylor, the result is that the agency, the FHFA, can stay, but the restrictions on the president's removal power, they have to go. Next, Alito turned to what relief the shareholders were entitled to in light of the constitutional violation respecting the president's removal power. Here, Alito wrote that the shareholders were not entitled to have the Third Amendment thrown out entirely because it wasn't implemented by a director of the FHFA. To the contrary, it was enacted by an acting director. And the court noted that the Recovery Act, which formed the FHFA, contains no removal restrictions on the president's ability to remove an acting director as opposed to a confirmed director. So the implementation of the Third Amendment by an acting director did not offend the Constitution. Interestingly, Alito also wrote that the subsequent Senate confirmed directors were constitutionally appointed, distinguishing the appointment of those directors with the Recovery Act's illicit removal provisions. And the court concluded that because the appointment of the directors did not violate the Constitution, their acts could not be considered void. Nevertheless, Alito left the door open a crack for the shareholders of Fannie and Freddie, writing that they might be able to prove that the unconstitutional removal provision inflicted some harm on them. What exactly that harm might be? Well, that's the lower court's problem to figure out. The court remanded the case to the Fifth Circuit, where the parties have been filing briefs arguing about what should happen next. I guess you'll have to come back next year for the rest of this saga, whatever that may be. Now over to Tim, who's going to talk about a case on personal jurisdiction.
Thanks, Eric. So in another follow-up from last term, Ford Motor Company was sued in both the state of Minnesota as well as the state of Montana. And so the name here, the Ford Motor Company v. Vandermeer, that's the Minnesota suit. And since the three of us are in our Minneapolis office, we use that name. But it was consolidated with Ford Motor Company v. Montana 8th Judicial District. So if you're looking for, again, the Supreme Court reported opinion, that's the name that it will bear. And this case is, I think, a potentially significant personal jurisdiction decision, and one that I think is also a little bit surprising given the Supreme Court's prior trend in jurisdiction decisions, but you wouldn't know it based on the unanimous result that the court reached here. So what happened in this case is it's a products liability case. Ford obviously has a footprint all over the country, and that's emphasized in the opinion. You know, they advertise everywhere, have dealerships everywhere, service vehicles everywhere. But here, there were products liability suits brought in Minnesota due to Crown Victoria that crashed in the state, driven by a Minnesota resident. Minnesota resident was injured, but the Crown Victoria was never bought in Minnesota. It was not built in Minnesota. The allegedly defective parts weren't manufactured or placed on the vehicle in Minnesota. Instead, all that was coming from other states or was manufactured in Canada. Same thing in Montana, which dealt with a Ford Explorer. It wasn't, the vehicle wasn't purchased in Montana. It wasn't manufactured in Montana. The allegedly defective parts didn't come from Montana, but it was a Montana resident who was injured driving the Ford vehicle in that state. And so suit was brought in the respective states, and specific jurisdiction was the basis for suing Ford there. So again, you have kind of two separate prongs for jurisdiction. You have specific jurisdiction and general jurisdiction. General jurisdiction has been held by the Supreme Court and narrowed in recent years to being clear that it's really just where the defendant corporation is, quote, at home. And Ford would not be considered at home in either Montana or Minnesota. And so instead you're dealing with specific jurisdiction, which is international shoe and purposeful availment and minimum contacts. And what the court has fashioned over the years and in its various decisions on specific jurisdiction is a multi-part test. The first one is that there needs to be purposeful availment. And so the defendant needs to have some meaningful minimum contacts with the state such that it's purposely availed itself of the right to do business there, and therefore isn't going to be surprised if it's also sued in that state or jurisdiction. And Ford concedes, again, that it does business everywhere, and so recognized that it had minimum contacts with both Minnesota and Montana. The second part of the specific jurisdiction test, however, is that there needs to be some sort of nexus between those purposeful availment activities and the suit in question. And the language the court has used is that the lawsuit needs to arise out of or relate to the defendant's minimum contacts with the forum state. And this is really what Ford focused on here, is that there's no causal connection in any way between Ford's activities with respect to this Crown Victoria or this Ford Explorer and the state of Minnesota or the state of Montana, right? So even though Ford does business there with these vehicles having been purchased in other jurisdictions, built in other jurisdictions, there's no nexus between the vehicles in question and Ford's purposeful availment in Minnesota and Montana. Now both Montana and Minnesota disagreed with that and said Ford is subject to personal jurisdiction. In Minnesota, at least, that decision was issued over dissent by two of the justices of the Minnesota Supreme Court. And it goes to the US Supreme Court, where again, there has been this trend towards narrowing the scope of where a defendant can be subject to suit. Here, however, all the justices unanimously agreed that specific jurisdiction existed over Ford. The majority opinion was, the opinion of the court was written by Justice Kagan, joined by Chief Justice Roberts, Justice Breyer, Justice Sotomayor, and Justice Kavanaugh. And the holding of the court was that when a company like Ford serves a market for a product in a state and that product causes injury in the state to one of its residents, the state's courts may entertain the resulting suit. What Justice Kagan did in her opinion is she again emphasized that Ford does business everywhere, and then focused on the language of the second prong and says that while the language that the suit must arise out of the defendant's contacts might indicate that there needs to be some sort of causal nexus, the other prong of that, which is that the suit needs to at least relate to the defendant's contacts, doesn't require any sort of specific causal connection between the specific suit being brought here and the general activities that the defendant corporation is doing. And here the court said that there's enough. Crown Vics are sold in the state of Minnesota, and Ford Explorers are sold in the state of Montana, and all of that was enough. What the court made clear to distinguish is that it wasn't that its recent decision in Bristol-Myers Squibb, which imposed limits on personal jurisdiction, was something different. Their plaintiffs brought suit in California, and Bristol-Myers Squibb did pharmaceutical business in California. But there, the distinction that the court drew in the Ford case is that there was no connection between the plaintiff's claims and the forum state, their California. The plaintiffs weren't residents of California. They hadn't used the product in California. They weren't injured in California. And they said that was a meaningful distinction between the Ford case here and Bristol-Myers Squibb. They also distinguished the Walden case that the court had issued. That was a case where the plaintiff was the only one who had contacts to the forum state. The defendant hadn't done anything there. And so the court said, again, this isn't Walden, this isn't Bristol-Myers Squibb. This is actually similar to the old worldwide Volkswagen case that the court issued back in the 80s, where it at least said in dicta, that was a case where a vehicle was purchased from a dealership in New York, caught on fire in Oklahoma. The specific litigant at issue there was the dealer, who only had a presence in New York, and the court said, well, there's no specific jurisdiction there. The dealer hasn't done anything to purposely avail themselves of Oklahoma, but did state in dicta that if Audi had been sued or Volkswagen had been sued, they would have been subject to suit. So that was the basis for the court's decision. In terms of what it means for the banking industry, I think it could potentially be significant. You know, banks do business everywhere. They have branches, you know, often not just in one state, but in multiple states. And through a network of ATMs, you know, arguably a bank is serving a market in every state in the country in some way, shape, or form. And so it does raise the question, especially if, let's say, a bank is doing marketing activities in one state, get a home mortgage with us, get a car loan with us, anything of that nature. The question that I think this case raises is whether it's enough if a resident of that state where the bank is advertising, doing some business, can that resident of the state bring suit against the bank in the state in which they reside, even if it pertains to a mortgage they have on their cabin that happens to be in another state, or you know, if they live and reside in Minnesota, but they're bringing suit in Minnesota with respect to the snowbird home they have in Arizona, or something of that nature. Those are questions that are going to come up. And you know, one thing that banks can try to push back on is this was certainly a products liability suit grounded primarily in products liability related precedent from the court. And so this case could perhaps be factually distinguished on that basis. Another thing that the court dodged here, but acknowledged, is that it doesn't address the internet age. You know, and it actually had a lengthy footnote saying, you know, we're not talking here about, and there are open questions about, you know, the small single place that sells things on the internet, using duck decoys as an example there. I think the long and short of it is that the question of how the internet age fits into personal jurisdiction is an open question. The courts acknowledge that it's an open question. I think another just practice point here is where there were concurrences were from Justice Alito, as well as Justice Gorsuch and Justice Thomas. And Gorsuch and Thomas both said it might be time to completely kind of rethink how we can think about personal jurisdiction. Maybe our efforts to pigeonhole it into this, you know, three-part test that we've had going back to international shoe doesn't really work anymore. And you're hearing that more and more from certain members of the court, particularly Gorsuch, Thomas, Alito. You're seeing more cert petitions that are directly challenging the court to reconsider past precedent. And so I think, you know, this is a day and age, and given the court's current composition, where those kind of arguments that past precedent isn't working, should be reconsidered, should be rethought. Those are questions that sometimes are gaining traction, and you certainly have particular justices who are saying, we're open to those kind of arguments, bring them up to us. And so I think that's something to keep in mind, both in the personal jurisdiction context and really kind of in any form of federal jurisdiction. If you don't like the precedent you're dealing with, don't be afraid to preserve the argument and potentially consider taking it up to the Supreme Court, because they are rethinking things in ways that they haven't been willing to expressly do in the past. Michael, I believe it's over to you now.
Thanks, Tim. So we're going to now move on to cases, well, actually one case that is going to occur, that the court is going to hear oral argument on in about 2 weeks, on November 2nd. This case, Badger versus Walters, has a really convoluted procedural history, but the question presented is actually rather simple. The procedural history just kind of illuminates how this question even arose in the first place. The key facts of this case are the plaintiff was employed by as an associate financial advisor by a company whose three principals were independent franchise advisors for a broker-dealer. And according to the plaintiff, those principals, the independent advisors, discriminated against her because of her gender in violation of Title VII. So plaintiff brought a whole host of claims in a FINRA arbitration against both the principals and the broker-dealer. The broker-dealer claim was effectively a Title VII claim. The claims against the principals were state law claims. The panel of FINRA arbitrators ultimately dismissed the claims against everybody. So plaintiff, believing that that decision was procured by fraud, brought a claim in Louisiana State Court to vacate the arbitrator's dismissal only as to the state law claims against the principals. So they dropped the broker-dealer basically from the lawsuit. So the motion to vacate, the petition to vacate the arbitrator's award only concerned the principals in the state law claim. The principals removed the claim to state court, or removed the claim to federal court, and then the issue came up. Does the district court even have jurisdiction to consider this petition to vacate the arbitration award? After all, the plaintiff was only seeking to vacate the claims regard the state law claims. The court, this came from the Fifth Circuit. Both the district court and the Fifth Circuit said, yes, there was subject matter jurisdiction. And so the analysis that they provided was, and this is where it becomes rather simple, it was a look-through approach. That what they decided was, if you look at the claims as they were brought in the arbitration, the underlying claims all together, and if they could have been brought in federal court, then there is federal subject matter jurisdiction. So the Fifth Circuit looked at the arbitration claims as they were brought, and sure enough, that is exactly what they could have been brought in federal court. There was a Title VII claim and supplemental jurisdiction over state law claims. So they provided, they employed this look-through analysis, and this analysis analogous to the supplemental jurisdiction analysis to determine that there was federal subject matter jurisdiction here. So the court is going to consider this question, whether the specific question involved is phrased as whether federal courts have subject matter jurisdiction to confirm or vacate an arbitration award under sections 9 and 10 of the Federal Arbitration Act when the only basis for jurisdiction is that the underlying dispute involved the federal question. And the court will decide that. We'll start to consider that in 2 weeks, and we will likely see a decision by June. This is kind of a niche question, but this will inform, a lot of litigation strategy. If there's a claim or a petition to vacate an arbitration award in state court, you may want to consider whether you want to vacate or remove that to federal court. There's more opportunity here, especially if the underlying arbitration award involved a potential federal claim.
Thank you, Michael. While we're searching for the CLE code, we're going to move on to petitions that are now pending before the court that are ones to watch, as well as some issues to watch. The first case is Branch Banking and Trust Company versus Sevier County Schools Federal Credit Union. This is a case that will be of particular interest to any bank that has had a merger lately. Such mergers involve any number of logistical challenges. The particular challenge at the heart of this case has to do with deposit agreements. At issue is whether there are limits on the extent to which an acquiring bank can amend a legacy deposit agreement to insert an arbitration clause. The plaintiffs in this putative class action opened money market accounts at a Tennessee bank in the late 1980s. The bank guaranteed that the annual interest rate on those accounts would never fall below 6.5%. At that time, as well, the bank's deposit agreement did not have any kind of arbitration or dispute resolution clause in it, a fact that's going to have heightened importance as we continue through this story. So as the years pass, this bank is acquired a couple of times over. The deposit agreement is amended a few times in the usual fashion, which is the bank makes the amendments, it notifies its customers, and it takes the position that continuing to maintain an account at the bank is a manifestation of assent to the amended terms. An arbitration clause is added this way in 2001 and it's revised in 2004 and again in 2017. So that brings us to 2018, and the ultimate acquiring bank is still saddled with these money market accounts paying out 6.5% interest, though they had taken, I think, the prudent step of cutting off additional deposits to these accounts some years previous. So the bank looks out the window, and the prevailing money market rate is like, you know, a basis point, as in 1 basis point. I mean, so they say enough is enough with this 6.5%, and they announce that they're going to cut the rate to 1%, which is not bad considering where market rates have been for savings accounts and where they're still at. But the customers, of course, say, no, we like the 6.5% better. Thank you very much. Representatives sue on behalf of a putative class in Tennessee state court. The bank removes to federal court and moves to compel arbitration. The district court grants that motion, relying on the arbitration agreement in the revised deposit agreement. The customers appeal, and the Sixth Circuit reverses in a 2-to-1 decision. And the majority opinion says that there was no mutual assent to the arbitration clause. It looks at the initial deposit agreement from the 1980s and says, essentially, the agreement may have allowed changes, but changes means changes to existing language. It doesn't mean additions. And this initial agreement doesn't say anything about arbitration or any other kind of dispute resolution. To make those additions, the court says you have to comply with the covenant of good faith and fair dealing. Now in Minnesota, the content of that doctrine is basically limited to not frustrating your counterparty's attempts to perform the contract. But here, relying on a California state case, the Sixth Circuit majority predicts that Tennessee courts would hold that good faith and fair dealing requires that you not unilaterally add completely new terms to an existing agreement. And it says especially not ones that cut off jury trial rights for customers. Now, the bank seizes on this last point in its cert petition, and it essentially argues that this construction of the covenant of good faith and fair dealing as protecting jury trial rights is really setting up a barrier for arbitration clauses under Tennessee law, because arbitration clauses necessarily preclude a right to jury trial, that other types of contracts will never have to face or surmount. And that discriminates against arbitration agreements as opposed to other contracts, and that violates the Federal Arbitration Act. Now, there are already a number of amici interested in this case, including the American Bankers Association and the Chamber of Commerce. So this is a petition that the industry already has its eye on, one that the wider business community has its eye on, and one that we think we all should watch to see what happens. There is another petition pending before the court dealing with arbitration. This one is Morgan versus Sundance. The Morgan case addresses the question, how long does one dare wait in a case before invoking an arbitration clause? In Morgan, what we have is an FLSA collective action regarding overtime wages. And instead of invoking the arbitration clause contained in its employment contract, the employer moves to dismiss in federal court, invoking the first filed rule in light of a similar case that had been filed against it elsewhere. Now, the court denies that motion, and the employer files an answer containing numerous affirmative defenses, but the arbitration clause isn't one of them. Then the parties go to mediation. And when only part of the case settles, then the employer finally invokes the arbitration clause and moves to compel arbitration. But now it's been 8 months since the case was filed, and the Iowa district judge denies the motion to compel on grounds of waiver, and the employer appeals to the 8th Circuit. Now, the 8th Circuit panel splits 2-1. just like in the previous case, and it reverses. And in a nutshell, the majority says, well, look, you didn't really litigate that much or that long. The motion to dismiss wasn't on the merits of the dispute. It was on the first filed rule, which the Eighth Circuit majority called quasi-jurisdictional. And the 8-month delay is largely attributable to the mediation and the time that the motion to dismiss spent under advisement sitting on the district judge's desk. And as a result of all those things, the employee can't show any prejudice, which is one of the 3 prongs we look at in deciding whether there's been a waiver of the right to arbitrate. Now, that requirement of prejudice, that as a party resisting arbitration, you have to show you were prejudiced before you can say that the party seeking arbitration waived its right to arbitration, that becomes the linchpin of the employee's cert petition. And the employee's argument is, look, waiver is just the voluntary relinquishment of a known right. That's it. That's what waiver is in the usual contract sense, no prejudice needed. By imposing a prejudice requirement in the arbitration context, what the Eighth Circuit is doing is putting arbitration agreements, again, on a different footing than all other contracts, and that is something that the Federal Arbitration Act forbids. The employee identifies a split among circuit courts and a split among states as to whether and to what extent prejudice should be a factor in determining whether someone has waived a contractual right to arbitrate. So it will be interesting to see if the Supreme Court chooses to weigh in. In the meantime, the moral of the story is waiting to invoke an arbitration clause is a dangerous game, quite a dangerous game. But sometimes you can roll the dice and win, at least here in the Eighth Circuit. And now I believe back to Michael.
Thanks, Eric. So the next petition before the Supreme Court that we'd like to take a look at is Weiss versus National Westminster Bank PLC. This is an interesting case involving the Justice Against Sponsors of Terrorism Act. As we all know, federal law prohibits providing material support to a foreign terrorist organization. The Justice Against Sponsors of Terrorism Act provides a cause of action for those who do aid and abet and provide substantial funds to a designated foreign terrorist organization. The question in this case is whether the mere knowingly transferring the funds to a designated foreign terrorist organization is enough in of itself to incur liability under JASTA. Now, the facts of this case involve a bank from the United Kingdom, NatWest, and they had been providing banking services to the Palestine Relief and Development Fund, also known as Interpal. And Interpal is a London-based nonprofit entity that also has significant ties to Hamas. The plaintiffs sued NatWest, contending that NatWest had provided material support to Interpal between 1996 and 2003 by processing at least 457 wires of funds from Interpal to 13 charities that NatWest allegedly knew or willfully ignored that were controlled by or were alter egos of Hamas. The Second Circuit was the district court had denied this claim, the aiding and abetting claim, because there was no evidence that that NatWest had actually been aware that by assisting the principal, it is assuming a role in terrorist activities. And the Second Circuit looked at the question and said, yes, you need more than just providing material support or resources to a foreign terrorist organization. There's a mens rea requirement there that is stronger. The exact wording is that the plaintiffs, in order to recover under JASTA, would need to show that NatWest was knowingly providing substantial assistance to Hamas, or that NatWest was generally aware that it was playing a role in Hamas's acts of terrorism. Here, it was involving transfers between Interpal and charities that were allegedly alter egos of Hamas, and the court held that there just wasn't enough there to impose liability under JASTA. This is not a new doctrine in the Second Circuit, but this is probably the first time that it's been seriously considered or brought to the Supreme Court. So this will be interesting to see what the court decides, if it decides to take up this case or not.
So this case and the next case that we'll discuss are ones that had been identified as petitions to watch and raised significant questions that the court could possibly have considered. Cert has been denied in both of these cases, and so that's why they're at the end and why we're giving them more passing attention. But I do think they can still provide some helpful guidance for the kinds of issues that, even though the court passed on them this time, could come up in the future. The first one that I'll discuss is California State Lands Commission v. Davis, and this is a bankruptcy-related case. And one of the issues that can come up in bankruptcy cases is what happens when a state gets involved in the proceeding. As a general matter, states can assert sovereign immunity to shield themselves from lawsuits. But there's been kind of an evolving question of whether states can do that in the bankruptcy context. Historically, the way that was first approached and kind of looked at was that Congress, by creating the bankruptcy court, Congress itself could effectively waive the state's sovereign immunity. So that was a theory. What the court subsequently adopted in Central Virginia Community College v. Katz was an alternative way of approaching sovereign immunity. And what the court held there is that states, when they ratified the bankruptcy clause of the U.S. Constitution, they by virtue of that ratification waived their sovereign immunity defense in proceedings that further a bankruptcy court's exercise of its jurisdiction over property of the debtor and its estate. So in other words, in rem jurisdiction. And this was the decision against Central Virginia Community College v. Katz that was issued in 2006. So what happened, the issue in this case is twofold. How far does Katz extend? And if it extends as far as the Third Circuit held it does here, should the court instead just reconsider Katz altogether? That was the argument at least put forth by the California State Lands Commission. So the facts of this case is that there was a business that engaged in offshore oil production, rented the offshore oil rig from the state of California, but then owned the onshore operation where it further processed the oil. For various reasons, the company went into bankruptcy. California got concerned that there's going to be, these oil production and refinery places that are going unused. There could be pollution issues arising from that. So it wanted the operations to continue. And at first had an arrangement to pay money for those to continue. And then when the company, as part of the bankruptcy proceedings, fully went under and another business was going to move in, the state of California said, well, instead of continuing to pay for the use of these of the onshore facilities, we're not going to pay you anymore, but they continued to be used. What this meant is that after the effective date of the debtor's plan of liquidation, the trustee for the debtor company brought a suit against the state saying that this is an inverse condemnation situation. The state of California is using the company's property, isn't giving payment for it, and so brought an inverse condemnation proceeding in federal court. The state tried to throw up sovereign immunity, and the Third Circuit came back and said no, citing Katz, saying that this action is one that is aligned and furthers the bankruptcy court's jurisdiction in an in rem proceeding, and therefore said that sovereign immunity did not apply. Again, the two issues that were presented in the cert petition are here. What the state challenged is that, again, when the cause of action is, when the suit's being brought against the state after the effective date of the debtor's plan of liquidation, seeking money damages from a state treasury on a claim that, again, this was the inverse condemnation. So it did not arise under federal bankruptcy law. It wasn't an insolvency claim. It wasn't a claim that was historically brought as a core aspect of the administration of bankruptcy estates. The argument was that sovereign immunity shouldn't apply here. The other question that was posed was whether the Supreme Court should reconsider CATS altogether. It's not surprising the court didn't grant certiorari here. There was no circuit split. The best hook was that this arose out of Delaware, and Delaware, everything passes through Delaware. There wasn't a square conflict with Supreme Court precedent. But I think the second question presented in particular highlights, again, that cert petitions can get people's attention, even if it's just asking the court to reconsider past precedent. You're seeing that more often, and you're seeing the court being willing to take those cases more often, even though it didn't hear. Eric?
Thank you, Tim. Next is the Nettles versus Midland funding case. Again, the High Court recently denied this petition, but it's still worth noting as it shows just how much Article 3 standing, and in particular, the application of spokio, continues to be a hot button issue, as it was in the TransUnion case that Michael discussed at the outset of the presentation. In this case, out of the Seventh Circuit, Ashley Nettles received a letter that overstated a judgment balance by $104. So what do you do when you get a dunning letter that has some mistake in it? Of course, you sue under the FDCPA, and that's what Ms. Nettles did. The judgment debt had arisen from a delinquent credit card balance. So Midland initially tried to force the case to arbitration, relying on the arbitration clause in the cardholder agreement. The district court denied that motion on the ground that the cardholder agreement no longer controlled because the debt at issue and the contract had merged with the judgment on the debt. Midland appealed that denial, and in the Seventh Circuit, in its brief in the Seventh Circuit, raised standing for the first time, which the court, permitted it to do because, as we all know, Article 3 standing is jurisdictional and has to be looked at by a federal court, no matter the stage of the case. The Seventh Circuit held that while Midland had misstated the debt amount, Nettles had failed to allege that that misstatement had really harmed her in any way. It rejected her contentions that becoming annoyed or having to hire a lawyer are cognizable injuries under spokio. And so the Seventh Circuit remanded with instructions to dismiss. So that's, with the recent cert denial, that's all that she wrote for this case, though one can expect plaintiffs will continue to try to chip away at spokio. And that's also all she wrote for this presentation. It is 1 minute before 4:30, and we're going to give that minute back to you. On behalf of Tim and Michael and Aaron, we want to thank you for attending today. We hope you enjoyed the presentation, and we hope that you will join us again in November for another edition of Dorsey's Bank Counsel Roundtable. Good afternoon and good evening.